As a finance professional in a disrupted business landscape, what does it take to be in demand? What does it take to attract great paying international roles? If you're an ICANN member, it'll just take one exam. That's all it takes to complete the globally recognized SEMA professional qualification and the internationally respected CGMA designation. As a SEMA member and a CGMA designation holder, employers will look at you as a finance professional, constantly acquiring new skills to add value to the business. That's why they'll be willing to pay premium to hire and retain you. If you have 5 years of relevant experience and are an ICANN member, you can directly sit for the final exam of the SEMA Professional Qualification, the Strategic Case Study exam. Start studying the SEMA Professional Qualification. Prepare to make an impact.
Save the date. Make it in October to remember as you register and plan to attend the second Save the date. Make it in October to remember as you register and plan to attend the second ICANN Annual Accountants Conference. Date 10th to 14th October 2022. Venue ICC Abuja and Sheraton Abuja. For more inquiries, call 070-501-80222 or 090-625-47263. You can also visit the ICANN website www.icanig.org to register. Thank you. The Institute of Chartered Accountants of Nigeria, ICANN, invites you to participate in the upcoming 52nd Annual Accountants Conference. Theme:
Good evening, professional colleagues. Good evening, friends of the Institute of Chartered Accountants of Nigeria. Good evening, our students. And ladies and gentlemen, you are welcome to another episode of ICANN on Air. This day, Thursday, the 29th of September 2022, which happens to be the last episode for the third quarter of the year 2022. And it is my pleasure to have joining me today my co-anchor Olamide Balogun. Olamide, you're welcome on board this evening.
Thank you very much, Mr. Olusegun FCA. It's a pleasure to be here, and we're ready to roll.
Yeah, we will be doing the work together today as we will be discussing a topic that is very germane and very topical to each and every one of us as professionals and as individuals, and it's will and codicil. What professionals need to know. And we will be guesting together with Olamide, Mr. JITI Ogунye, a lawyer and a principal counsel, JITI Ogunye Chambers. He was actually called to bar in 1992, following which he joined the law firm of Mr. Femi Falana Chambers, where he worked for 8 years and served as deputy head of the chamber. In 2000, he established JITI Ogунye Chambers, a general practice law that conducted cases and continued to handle cases in all branches of law. He was a member of the Campaign for Democracy, CD, where he worked with the likes of Dr. Beko Ransom Kuti, also a member of the Central Committee, expanded secretariat, also a member of the Committee for Defense of Human Rights between 1995 and 1999. I'm sure you know that Mr. JITI Ogunye is not a stranger to every one of us. He's a man that has achieved great landmark fighting for human rights. And I can tell you that he's a leading public interest lawyer, publicist, a law reporter, legal commentator, and author. He is very, very fast and has written hundreds of law, human rights, democracy, and development related articles in print, media, and learned journal. And he has authored 3 publications to his credit. Married to Comfort, Ogoye, a loyalty and woman rights advocate, and they are both blessed with 3 children. Olamide, I'm sure we are fully prepared for Mr. JITI Ogunye this evening. So on this note, without wasting our time, I'll quickly go on a very short break, understanding that commercials is what pays the bill for this
Absolutely.
program.
It's going to be a wonderful show for all our guests joining us across the diaspora.
Yeah, that's nice to hear. So I'll be going on a very short break, and when I come back, I'll be coming in with our guest, Mr. JITI Ogunye. Stay tuned, and I'll be right back.
Dear professional colleagues, these are undoubtedly unprecedented times. Social and economic indices are undoubtedly performing below all expectations. No nation is spared, not even the advanced nations. Global community is battling environmental, economic, technological, political, and social challenges all at the same time. Most developing economies are experiencing rising unemployment, spreading inflation, escalating and humiliating poverty, security breaches, trade wars, tensions, political instability, and deteriorating climatic changes with all their consequences. As professional accountants, we must ceaselessly support government and business leaders in charting a robust and viable future without neglecting the current needs. As we strive to prosper financially, we must do so through sustainable methods, creating value while ensuring we pay adequate attention to the climate. Ladies and gentlemen, this is the focus of the ICANN's 52nd Annual Accountants Conference, the theme of which is Nigeria Adopting Sustainability for Economic Prosperity. I invite you all to join us as we learn and relearn from indigenous and international resource persons between October 10 and 14, 2022 at the Abuja International Conference Center. It surely promises to be a truly transformative experience. See you in Abuja in October. Thanks and God bless.
Well,
Welcome back from that brief break. Our guest, professional colleagues, friends of the Institute of Chartered Accountants of Nigeria. As been said earlier by Mr. Olusegun Ogunade, FCA, we will be having a great guest in our midst today, the person of Mr. JITI OgUNYE, and is rightly on board right now. Mr. Ogunade, over to you.
Thank you very much, Mr. JT, and you're welcome on board. Good evening, sir.
Good evening. Thanks for inviting me.
Our pleasure always. Sir, let me start straight out. We'll be talking on the will and code. And I want to start in this manner. As a highly revered legal luminary of note, we want you to elucidate for the benefit of our teaming global audience the difference between will and codicil.
Well, thanks for inviting me. The topic you've chosen is a very important one because of what it is. A will is a testamentary and revocable document voluntarily made, executed, and witnessed according to law by a testator with a sound disposing mind. By that will, the testator disposes his property subject to any limitation imposed by law, and then he gives such other directive as he may deem fit to his personal representatives, otherwise known as his executors, who upon his death and after his demise administers his estate in accordance with the wishes he had manifested in his will. Now, let me break it down. Will is quite, a familiar word, and so when somebody passes, the question is posed: did he leave a will? Did he leave a document by which his asset, while he was alive, could be shared amongst the beneficiaries of his estate, principally his children, family members, his relative friends, and then shared to causes within the philanthropic spirit. So everybody is quite familiar with what a will is, I guess. However, to break it down, a will must be a written document as prescribed by law. So you can't have an oral will. In other words, it's not possible for you to talk about a will that, it is the will of the deceased, just the ordinary word, as if something that somebody wanted, his will, his mind. That's not the sense in which a legal will is described. So a will must be written, and that is prescription of law. It must be made by a testator. A testator is the deceased who in his lifetime made that will. Then that will must distribute assets. A will that talks about wishing the family well, saying bye-byes and all that, properly speaking, is not a will because it has nothing to distribute. So it must have things to distribute, property to distribute. And that will must then appoint executors, personal representatives of the deceased or the testator, who upon death will take over and then distribute the assets after the person has died, according to his will, according to his preferences, according to his prescriptions. Now, executors of a will duly appointed by the testator have the power immediately upon the death of the testator, the deceased now, to take over affairs, even though that will is yet to be admitted to probate. And I will explain. When a will is written, when it's made, properly executed, with two witnesses being there together, and the testator, so that while the signatures are being subscribed, the two witnesses will witness it as the act of the testator. Because if they didn't do so, that will implicate the validity of that will. So once this is properly done and all that, that will is then deposited either in a bank or in a safe custody or in the registry, probate registry, in the high court of a particular state. And once that person is dead, the executors will now come forward and say, we have a copy of the will, or we know where the copy of the will is located. We now want to prove the will. We want to propound the will. We want to establish the will. And then the probate registry will then admit the will to probate. And then it becomes a legal document that can be enforced. Now, a codicil is also a will, but it's a miniature will. It's a small will, and it is used principally as an amplification instrument or a clarification document or a revocation document. And I will explain. After a testator had made a will, maybe at mid-age, maybe in his 50s or in his 60s, and these testators then went ahead to live up to a ripe age of 90 and all that, the possibility, nay, the probability is that he will continue to acquire assets. He will continue to have means that the will had not covered, that the will had not distributed. So a codicil, which is a smaller version of a will then distribute those additional assets or accretion in property as an addendum, yes, to that will. So the will and the codicils will then be read together upon that once they are admitted to probate. A codicil could also be used to revoke a will. You had made a will earlier and you are dissatisfied with that will. A child had become so irresponsible, you don't want to provide for him. A wife had left, a husband had left, a property had been destroyed by fire, something had happened. So you now want to make a fresh will. You can either use a codicil to revoke that will, or in the latter will that you are making, because there can be many wills. In the latter will you are making, the first thing you do is to revoke all earlier wills that you have made, so that the latest will be known as your last will. That's why will is usually headed the last will of Mr. X. So codicils and will are of the same genus. They are the same genus. They are the same family. And that's what I can explain in respect of that.
Sincerely speaking, you've given a deep insight into what will and codicil is all about. In fact, question I've started pumping in on the definition you said, and possibly might want to take that, because you said a will must be a written document made by a testator with the focus having something to distribute, that is assets. And that testator must appoint an executor, witnessed together by two people. And when that is done, you put in a probate registry. And you spoke about codicil. But while you are giving that definition, a question pumped in from our audience. And somebody is asking, sir, with the advent of this technology, can't we have a testator having a recorded version of what his will is going to be, and possibly save in the cloud and retrieved it? That is a question from Sheon before I hand over to Olamide. Help us do justice to that, sir.
Now, wills and codicils had their origins and foundation perhaps in medieval times, in time past. And so assets and property are as old as mankind. And so before the written word was discovered or established, people had, we must assume, there are ways of distributing their assets by oral means. And that is also recognized by law in a way. It's called non-cooperative will, oral will. And in some traditional society, this is well respected as the wishes of the dead. You don't want to obstruct what the dead had said, and so on and so forth. In those kind of societies, because sanctions from the dead will apply. Now, technology makes it possible for the kind of preservation that the person who posed that question has talked about. Because written wills in certain cases have been found to have developed legs. Wills were written and then they could not be found because of vested property interest. Even for the most look. I don't say this lightly. We in many of the famous cases that we had, the rich, the property class, and the powerful and the educated have been embroiled in litigations over wills. We know about the Williams family, and this is unfortunate. Chief Rotimi Williams, Senior Advocate of Nigeria, was a doyen of law, respected. He practiced law in Nigeria over 50, almost 60 years. He was the first black man to be an attorney general on the African continent, attorney general of Western region. He had one wife, he had 4 children, and he died, and then the will became a problem. And that problem was never resolved, as at the time the first son, a senior advocate of Nigeria, also died. So, and we had other cases like that. So even with a well-kept, well-written, controversy could come. Therefore, technology can aid preservation and keeping of the will, so that thereafter you won't have this problem and all that. And this can always be assessed, and then it can be propanded, and then it can be taken to probate registry. But it will still have to be proved, because again, technology is not free of manipulation and doctoring also. And talking about recording of the act of disposing these assets and making arrangements about a deceased, including his death, because it's not only about assets. Some of the wills are written in my professional life, many of them, very wonderful documents. Some, give details about burial expenses and all that, because some persons don't want burial expenses to be borne by their children or family. So they already set money aside to cater to that. Now, you will realize that many Nigerians who are familiar with the African Magic series, particularly the Yoruba type, in some movies where you have people reading, slotting tapes and all that. Yes, this is permissible. However, by law, such tapes and all that alone can be substituted for a validly written and made and executed will. So if you go have some recorded tapes and you want to use that as substitution, the court will not recognize that. The law will not recognize that. It must be written. So in addition, therefore, to a written will, yes, tapes can be recorded, video can be recorded, and all that, and that will serve as supporting the will when it is being proved and when it is being read and when it is being executed, so that nobody will be left in doubt as to the authenticity of that will and the will and preferences of the testator who had made that will. Because as it is said, pictures don't lie. Yes,
Wow.
it's something could be explored. And by the way, which is very interesting, when Chief Gani was making his will, and he made his will, it was his junior who made his will, Chief Gani of blessed memory, who once worked with him, Oyetibo, senior advocate of Nigeria. Pictures were taken, there were recordings, it was elaborate. Chief Gani was a man of record. His capacity for record keeping was legendary. So, and he did everything perfectly and all that. So yes, recordings can be made, pictures can be taken. It will only aid in proving the will when issues of controversy arise.
Thank you very much, sir. That's a very detailed breakdown to the question. For our professional colleagues and members who are just joining us, we've been talking to JITI OgUNYE, a senior lawyer in Nigeria, and he has been taking us through will and codicil, what professionals need to know. Sir, permit me to follow up with this question. We've also heard about private living trusts, and it seems to have similar features with a will. So, sir, could you please explain if there's a difference between a private living trust and a will?
Yes, they are similar, but they are different. Yes, they have similarity, but they also have differences. A will is testamentary in nature, meaning that it's ambulatory, and I'll break it down. A will does not start working or functioning until the testator, the maker of the will, has died. And of course, in that will, executors will be appointed who will act as the executors and could later act as trustees if there are some residuary assets or legacies to be taken care of after the assets have been shared. With a living trust, what you have is that a trust deed, a trust agreement, that's what it is called. Deed is an agreement. A trust deed is made by a living settlor. These are archaic times, it's like settlement. A settlor or a person who, like a testator, will appoint somebody else to be his trustee for the benefit of a beneficiary. For example, somebody can have some property. It could be pecuniary, it could be monetary property, liquidated money, or it could also be property, real property. And then the person, by trust deed, passes that property to a trustee to manage that property, take care of it, turn it to accounts for the benefit of a beneficiary who could be his son or anybody who is also living. So unlike a will, a living trust, that's why it is called a living trust, takes its effect while the settlor is alive. It has taken effect immediately or on an appointed day. Now, if the beneficiary predeceases the settlor, the person who made that living trust, that would then mean that that living trust had collapsed at that point because the beneficiary is dead. Except, and it's not usually the case, the person who made that living trust then said upon the death of the beneficiary, if he had a son and all that, he would then be the one to continue to benefit, just like the person who is the major beneficiary before he passes. Now, the other difference is that if the beneficiary survives the person who made the living trust, and the person who made the living trust did not have a will or had a will and excludes that property over which he had created a living trust, that living trust will terminate upon his death because it is called a living trust. It is when the person is alive, who made it while he's alive and is still alive, that trust arrangement can subsist. Once it dies, that living trust dies. That's the major distinction between it and a will. But let me add that there are other ways too of dealing with property. You can have a deed of gift in the lifetime of the person that is giving it to a person, and that property will not be captured in a will of a person. But there are advantages and there are disadvantages. There are the spouses who, after they made a deed of gift to a person, the spouses could separate and then there will be a problem. The child could become irresponsible and then there could be a problem. Whereas the person who did that, who made that gift, was doing that to resolve problem because maybe he suspected that if he were to give those assets as bequest in his will, his executors, who might be family members, might not faithfully execute the will the way he wanted. So in his lifetime, he wanted to share his property by deed of gift and all that. But the prodigal son, upon taking a property, for example, would then sell it off and go and play mbet or something. So what then happens? So there are advantages and disadvantages and all that. But that's the major distinction between a living trust and a will.
A well-detailed lecture on that particular question raised by Olamide. And I want to take this from the angle of the professionals. Sir, can an individual or firm of accountants, solicitors, or arbitrator act as trustee in private living trust?
Yes, of course. Of course. And that should also be encouraged. And that's why, because you are professionals in this regard, because you may want to know, can you act in this regard as executors or even in a private living trust, act as a trustee? Of course, yes. And I think that, organizations are run by human beings. And human beings are no robots. They come under all sorts of influences, and they are susceptible to all sorts of, biases and things that are good and things that are not that good. Particularly when dealing with lost property or dealing with the property of those who are dead. There's some people who are so morally upright, and it is not because of the constraint of law that they will not fiddle with trust property, but based on their beliefs and moral, constitution, that they will not do that. But the law is there to govern everybody. In many cases where individuals, friends, subordinates, associates, family people are made executors and all that, and trustees, we've seen some problem. And so, because it's a public matter, and because I respect that example so much, and and we had some relationships, and I respect, and if it's a matter of public domain, although will is a private matter, but it's a matter of public knowledge, I will cite that example. When Chief Ganifa was passing, and the will was published in the newspaper anyway, he made a will. And what he did was instructive. He appointed First Bank public trustees, and this is not supposed to be an advertisement, as his executors. That's a famous lawyer. Perhaps, arguably or unarguably, the most famous lawyer Nigeria had ever produced. And he appointed First Bank trustees to act as the executors of his will. He had children who were lawyers who could serve as his executors. But he didn't go that route. He didn't go that route. He just did what he had to do. And if you ask me, that company had discharged his remit very well. He died many years ago. The Nigerian Weekly Law Report, which is the leading law report in Nigeria, that been published without any break since 1985, upon his death, that Nigerian Weekly Law Report survived. I won't put it to the work of First Bank public trustees alone. There are lawyers who are doing that, who are committed to the process, the family, and all that. But people are told that how to be preeminent, premier law report in Nigeria, how will it survive? Okay, so it may even be safer. And I'm not saying that there are any cases of companies or trustees who could engage in unethical practices. It may even be safer for companies and professionals like yourself, acting in companies, of chartered accountants and all that, to take on the job of those trustees and executors. That's my take, and I'm saying this without any pandering, regardless of the fact that I'm a lawyer. I'm an executor in a number of things that I've done for some clients, but that's their choice. And so a company like yours could then act, and in that case, you won't have to be two companies. The company soul and then act. Whereas if you are dealing with individuals, you need at least two executors and all that. Yes.
Wow. Thank you. Thank you very much. That's indeed very eye-opening. It's another avenue for our members, chartered accountants, to tap into the available resources open to them to be executors of wills.
Yes.
For our questions are coming in from our viewers all over the world, and I have one here, sir, for you from Bawa Rashidi. He says, can a will be changed or altered after the death of a testator? If yes, what are the process of changing a will?
A will is sacrosanct. Once the testator dies, any attempt to change that will becomes a criminal offense. You can't do it because you are not the maker. The maker of a will is the only one that has the prerogative to change it. He can revoke it, he can amend it, he can do anything with it because he's the one that made that will. But once he dies and somebody then tries to change it, it becomes a criminal offense. So to answer your question directly, a will cannot be changed after the death of the maker, the testator. I must clarify, however, that the executors of a will who are appointed as executors, who have been charged to faithfully execute that will, also cannot change that will. Look, I give you another example. And this may shock you because it's full of example. And it's exemplary because indeed he lived an exemplary life. Shiga, if I mean his will, decreed that his law firm be wound up. That law firm was one of the most resourced law firms in Nigeria, if not the most resourced, in terms of materials, in terms of books, in terms of publications, in terms of the number of lawyers that were there, in terms of asset, building, and all that. And it was tough. We're talking about a man who had sired many lawyers. At his death, he had about 4 or 5 lawyers as children. But the family faithfully, and the executors faithfully. It wasn't easy because some of us were even wondering, that's like a monument. That's a legacy. Why should this happen? But that's his will. And so, in spite of the difficulty, it was obeyed. And the chambers was shut. So we now have a gallery in Ikeja, tall building, fine building, but that's a gallery. That's where the books are. That's where the papers are and all that. But it's no longer a law firm. Okay? So a will once made can only be changed by the maker. It cannot be changed by the executors and all that. However, the executors have some, if they have latitude in the will to execute, to invest money, for example, they can decide where to invest money and all that, and they will be guided. But not that they will then change the will. Nobody can change the will unless the testator changes the will himself while he's alive.
Nobody can change the will except the testator do that while he's alive. I have this question coming on board that is next of kin entitled to collect the benefit of a deceased relative, especially when he has spouse and children?
Now, I'll answer the question this way. It is not so, but it may also be so. And this is not typical lawyers double speak, no. But I'll demonstrate, yeah, because the lawyers speak on both sides, no, it's not true. So I will just demonstrate, how it can be so and how it may not be so. Now, if the subject, a property, now money, for example, benefits of a deceased is already captured in a will of that deceased. That money, that benefit can no longer be dealt with except as prescribed in that will. That's number one. So whether there's a next of kin or no next of, for example, if a military officer were to make a will, and in that will, he had stated how, if he were to die while still in active service, his benefits, death benefits should be dealt with. And that will is deposited in court and is registered and is, submitted to prove it. Whatever comes out from the Nigerian Army or Armed Forces will be subject to the dictate of that will. However, if that kind of person died intestate without leaving a will, and he then left a next of kin, if that next of kin is not the wife or the wives and the children, that next of kin may be entitled to collect that benefit. Now, But if he collects that benefits, he becomes a trustee of that benefit, a constructive trustee of that benefit for the benefit of the family. In other words, when somebody appointed a next of kin, it's not for the next of kin to take the money and use it for himself. So if A was a next of kin to B who died, and the B had children, C, D, F, and then A, as a next of kin, just collected the money and voted, well, they said, come, you are just a trustee, constructive trustee. Yes, you are only appointed by a deed, but you are just the money, we are his dependents. So they are entitled to retrieve that money from that next of kin. The law will aid them to do that. But if that person who died now married under the act, there's a statutory marriage under the marriage act, where a spouse is entitled, a surviving spouse is entitled to the benefits of what the late spouse had owned. Those provisions of the law will be invoked, so that even if you have a next of kin that is different from the spouse and the children, because the law has said that they must inherit the person that is dead. If he didn't leave a will, their position will be superior to the position of a next of kin.
Yes, sir.
And so they can access that benefit ahead of that next of kin, who may not be the family member. So the family of a deceased are not that vulnerable without the protection of law, but many assume that they are helpless and that they cannot do anything, when such an unfortunate thing occurs. That's not so. The law is not that helpless and silent.
Okay, it's good to know that. Thank you so much for shining more illumination into the present situation and the question that was thrown to you by Mr. Okwade. Following swiftly as we gradually wrap up, sir, one of our audiences also posed the question. Ojegbede Abdul Kabir is asking, at what age is it ideal to write a will? But I'll also tie that question by saying that, why is having a will so important?
Okay. First, at what age? Generally, under the law, a minor cannot make a will, but a minor cannot make an agreement. If you don't attain the age of majority, 18, which is like the voting age, many ages and all that, you cannot, make a will. Or in some cases, age 21. So it's not just a will, it's just generally all forms of agreements and so on and so forth, like conveying property and things like that. So age, therefore, presupposes that from that age of majority, you can make a will. Whether you're married or you're not married, if you have assets, you can decide to make a will about it. If you have a notebook in your secondary school and you're above that age, or in your university, you can make a will. That's what it means, and that kind of thing. But talking seriously, everybody wishes to live to a ripe old age. And I would say that once somebody becomes responsible, and I'm not saying that those who are not married are irresponsible. Once, I'm not saying that. Once somebody has a family, or if not even a family, because look, Catholic priests do not have children by the oath of celibacy, right? But they are not from making a will. In making a will, they may, or their personal properties and all any property they may have, they may turn it over to their church or over for some philanthropic purposes and all that, but they are not stopped or prohibited from making a will. So it's not just about when somebody marries, then you have to make a will. That's the point I'm making. So once somebody is from 40 years, if you ask me, 35 upward, the person should think of making a will. It doesn't need to be a huge, elaborate process. As the Yoruba will say, and I don't know whether any one of you will help me translate it, or I can even offer a translation. You know what I say? You know, the literal translation is that those who have money are the ones that can make big fetish. You know, yes, it is the measure of the size of the fetish you get to protect yourself will be dependent on the size of your pocket.
Money.
So yes. So the point is that if you have little property, make your little will, maybe 1-2 pages. But if you are now like, let me borrow the Nigerian lingua, the balance. If you are blown, so you can then make maybe a book of a will and all that. So, and one can make such will. Now, because a will, particularly by property families, property and greedy family members, you know, because they can contest the validity of it when they realize that it doesn't favor them. So my suggestion would be that when somebody is already 70, 75, and all that, is getting too late to make a will. Because at that age, you know, you have all that, you know what you want to do about your life and all that. So you should be able to make a will, you know, when you are in your 40s, in your 50s and all that. 70, 75, 80. Why that may be getting too late is that if that person has huge assets and he then made a will, very beautiful will at that age, he had a sound disposing mind. His brain was still alert. He's still mentally alert. After the person passed, some of the people who are disfavored by the will or who felt that they weren't well given, they weren't well taken care of. We then go to court and start challenging the soundness of the health or mind of their father. And saying that he didn't have a sound disposing mind. Or he was manipulated, he was induced, which are grounds for voiding a will by a court. That yes, our mother, yes, we are the first set of children. Then at a certain age, our mothers got separated, and he got this manipulated. The young woman manipulated him, and then he willed the asset. So he didn't know what he was doing. He was mentally not sound. He was and all that. But if the person were younger, that kind of thing, except there's evidence to show that the person really didn't have a sound disposing mind, that kind of allegation would not arise. So the ages I've mentioned, it's good to make a will.
But sir, sincerely speaking, time is not our friend. Before I give the parting shot, I don't know if I have a series of questions. I'm sure you know the importance of this. If we can still take your time next week Tuesday, sir, this same time. It's a germane topic. I don't know if you can oblige us your time, sir. I have a series of questions we've not even tackled at all, and our people are yearning for it. I don't know if I have your commitment for next week Tuesday, sir. Same time.
Tuesday or Thursday, you said?
No, Tuesday. The program is every Tuesday and Thursday. So the next edition is a Tuesday. If I have your commitment, sir.
I will have to check that. Okay, let tentatively let's say that we will agree. But I'll
Thank
have
you.
to check. want to check my
Thank you
schedule.
very much, sir. I know that
Thank you,
the
sir.
creation of the time will be there.
I want to check my schedule.
We've already thanked you. So
Our
Because
people
we're
ask
taking 1
series of
hour.
questions so that
Okay.
I can bring that up next week Tuesday so that we can
Okay.
have the part 2 of it. This is really educative and our members need it. But we have less than 5 minutes to go, and I want to take this in 1 minute, sir. As
Okay.
your parting shot, what do you feel the professional accountants or professionals indeed need to know about the importance of the will that we're talking about so that we'll coast you till next Tuesday?
Now, I think that why professionals like professionals like yourself, accountants, should be interested in will. It's not just because, although they are professionals, they're also responsible persons. They are Nigerians, they are human beings, they have their own personal affairs, so they should also be interested in how they would make wills for themselves. That's not just important. The other reason they should be very interested in it is that in your line of profession, for many reasons, you may be called upon to help tidy up accounts. There's some firms that do the job of dealing with trust properties, dealing with property dispositions made under a will, and then they render accounts. They may not be accountants themselves, but they have to render accounts because they are trustees. Executors are trustees. So, in discharging your duty to them as accountants, you must ensure that the highest standards, the highest ethical behavior, all these are put in place to ensure that you remain the good professionals that you are. Because those who abuse trust of those who are dead, particularly if the property is much, or those who are even living, in the case of living trust that you mentioned, they usually need accomplices and people to act as their collaborators, particularly when it has to do with money. And so, because they themselves may not have the expertise or the professional knowledge or the qualification to do the accounting themselves. For example, if as an executive, for example, and I'm asked to do something related, and they have to render account, I won't do the account myself. I will need to. So those professionals have to ensure that in dealing with such trust property, they have to bear it in mind that this property that they are dealing with is a trust property or is a property under a will that has been executed, and that somebody puts a trust in them, and that therefore they must continue to act professionally within the boundary of law.
Thank you very much, sir. Thank you very much.
Wow.
Time is not our friend, and I sincerely want to appreciate for agreeing to be part of, to be on the show next week, Tuesday, where we'll do more justice to the question of our guest. To all our viewers, I sincerely want to appreciate you for being part of the program with today. I'm actually being guesting Mr. JITI Ogunye, a legal luminary, until we come your way again next week, Tuesday, where we'll be starting another quarter. Myself and my co-host will remain humble. I will say, stay tuned, don't go anywhere, and stay tuned with us next week, Tuesday. Bye for now.